So, if we trace this back to 1954, you have technicians from Eli Lilly, right? And they acquire this specific plant from Madagascar, the rosy periwinkle.
Right. And you have to look at the context there. The indigenous Malagasy people had, they'd utilized that exact plant for generations. It was a traditional treatment for diabetes.
Exactly. They had this foundational understanding of the biological utility just through, centuries of direct application. But Lilly's researchers didn't just observe the remedy and try to replicate a tea.
No, they didn't. They took the raw physical plant material straight into their laboratories. I mean, they initiated a highly specific, very modern extraction process.
The goal was to separate the raw plant matter from its most active molecular components. And during that rigorous extraction, they managed to isolate two very distinct chemical alkaloids.
Right, which we now know as vinblastine and vincristine.
Yeah.
And while they were testing these newly isolated compounds, the lab techs noticed something else entirely. They observed this aggressive drop in white blood cell counts in the test subjects.
Which was the ultimate pivot point. Eli Lilly realized that intentionally dropping those white blood cell counts could actually be weaponized against certain cancers, specifically childhood leukemia.
Yeah, they identified a completely novel utility, something totally separate from the traditional diabetes treatment the Malagasy people used it for. So naturally, they immediately filed an application for a United States patent.
But crucially, and this is where the mechanics matter, they didn't try to patent the rosy periwinkle plant itself. You can't patent naturally occurring organisms under the statute.
Exactly. Instead, they claimed the highly specific process of isolating those exact alkaloids, right? They patented it as a targeted treatment protocol for cancer.
And the resulting pharmaceuticals, which eventually hit the global market as Oncovin and Velbin, they generated over $100 million annually for Lilly, every single year for the duration of that patent monopoly.
Meanwhile, the indigenous Malagasy people who maintained the raw knowledge and actually guided those initial researchers to the asset, they received $0.
Nothing. Because while they possessed the foundational knowledge, they completely lacked the legal architecture to monetize it.
And look, we are not framing this as some moral failing or a story of corporate greed. You really need to view this outcome through a strictly analytical lens.
Right. This is a mechanical discussion about how rules are applied on the board. The Malagasy held the physical plant and they held the knowledge, relying on tradition and communal understanding.
But Eli Lilly held the United States patent claiming the isolated chemical compound derived from that plant. The system didn't break here, It functioned perfectly according to its design.
Because the United States Patent Office does not reward the origin of an idea. It just doesn't. The system rigidly, exclusively rewards the precise act of isolation and formal documentation.
If you don't formally isolate and document it, you basically do not exist in the eyes of the system. It's that simple.
So, to understand how this massive wealth transfer is legally justified, you have to understand the statutory promise. The written law operates on this very specific foundational trade between the inventor and the public.
Right. The office basically demands a perfect, replicable instruction manual of your invention. And in exchange for that complete technical surrender, they grant you a temporary, federally recognized monopoly.
It's a highly calculated transaction.
Yeah.
So let's actually examine the precise text that governs this trade, because the language of the statute dictates your entire strategy.
Imagine you're a technical founder, okay? But instead of software, say you're a baker who has perfected a master recipe. And this recipe just entirely outcompetes every other bakery in your local market.
Your operational edge is based entirely on the secrecy of your, specific hydration ratios, your fermentation temperatures. As long as those metrics remain locked in your head, your market position is completely secure.
Right. Your competitors can buy your bread all day long, but they can't reverse engineer the actual process. But then you decide you want formal, government-backed protection for this recipe so you can scale safely.
So you take your master formula, detailing every single temperature curve and exact measurement, and you essentially hand it directly to the town crier. You tell them to read it aloud in the public square.
For all your competitors to hear. And you execute this extreme act of total transparency because you're operating under a very specific assumption.
You trust that the mayor will automatically deploy the police to arrest anyone who tries to bake your bread using your newly publicized instructions. You believe the disclosure guarantee is a protective shield.
And this specific exchange, this trade-off, is the legal concept known as the enablement clause. It's codified explicitly under Section 112 of the United States Patent Act.
It's also mirrored globally in Article 29 of the TRIPS Agreement. So this requirement is standardized across international borders. The statute demands you disclose your invention with absolute structural clarity.
Right. The written legal threshold is that any person skilled in the art has to be able to recreate the invention purely by reading the document.
And the critical phrase in that statute you really have to focus on is without undue experimentation. You can't hide the most crucial steps of your manufacturing process.
Exactly. You can't leave out the specific solvent that makes your chemical reaction work or the exact temperature threshold. You literally have to lay the entire functional pathway bare.
So a careful technical founder reads this statute and logically concludes, it's a rational, fair trade. You surrender the proprietary mechanics to the U.S. government, providing the exact blueprint of your life's work.
And in return, you believe the government provides you with a 20-year ironclad monopoly over that method. You feel secure because you followed the rigid rules of disclosure.
You assume compliance equals protection, but that perceived security relies on a second statutory pillar working entirely in your favor. So let's shift the analogy to understand how this second rule functions.
Okay, let's hear it.
Imagine a highly trained security guard, stationed at the front door of your corporate headquarters. You're watching on the security cameras as a thief walks out of the lobby carrying your proprietary prototype bicycle.
The security guard observes the entire physical event, makes eye contact with the thief, but officially permits the theft to occur.
Yeah, the guard allows the thief to walk out the front door for one highly specific technical reason. The thief stopped in the center of the lobby and painted the pedals of your bicycle red before exiting.
Because the addition of the red paint changed the legal classification of the object, which brings us to the novelty requirement.
Right. You'll find this strict legal threshold under Section 102 of the Patent Act. This is the ultimate filter that determines what is actually allowed to receive federal protection.
For an invention to receive patent protection, the statute dictates it must be new and non-obvious. And foreign innovators, or people relying on traditional knowledge, they read this language and assume it acts as a permanent defensive shield.
They expect this statutory standard prevents any heavily capitalized competitor from patenting their pre-existing knowledge. Because the logical assumption is, if the knowledge already exists in the real world, it can't be classified as new.
Right, so it can't be enclosed by a patent. And the written statutes read flawlessly on paper. They really project this aura of absolute mechanical protection in exchange for your technical transparency.
The text implies a perfectly balanced scale. But that is the pure theory of the law as written by legislators. To survive as a founder, you need to understand what actually happens when your application lands on an examiner's desk.
Because the theory rarely survives contact with the bureaucratic reality, the reality of the Patent Office immediately dismantles those carefully constructed expectations.
You need to visualize the actual physical constraints placed on the examiner who is reviewing your core technology, because examiners are not investigative journalists.
No, they are not. They do not leave their offices to verify the physical origins of an invention. An examiner does not conduct field research in the global south to verify the history of an herbal remedy.
They aren't visiting your manufacturing floor to see your prototype in action. Their entire professional reality is confined to the specific, digitized databases they search from their assigned workstations.
And they operate under brutal production quotas. An examiner has roughly 19 total hours to read your complex technical specification, search all of human history for prior art, formulate a legal rejection, and write the formal office action.
That 19-hour constraint dictates their entire methodology. They can't browse the library. They must rely exclusively on highly structured Boolean search queries.
Right. They search internal databases like East and West for very specific keyword combinations. If your pre-existing knowledge is not tagged with those exact keywords, the examiner will not find it.
Which introduces this devastating procedural reality for traditional or lean innovators. If a foreign innovator relies on knowledge passed down orally for generations, it essentially doesn't exist.
Or even if it's utilized quietly in a closed manufacturing loop, it effectively does not exist to the federal government. United States law explicitly dictates the strict boundaries of what qualifies as prior art.
Foreign knowledge or traditional practices only defeat the novelty requirement of a new application if that knowledge is documented in a printed publication or a widely available database.
We call this the rule of print. You could have a documented 1,000-year history of a specific indigenous community utilizing a biological process, and it won't matter.
If that exact process wasn't formally published in a peer-reviewed journal or an index textbook, the office cannot legally cite it against a new competing application.
And this structural blindness built into the search process creates what we define as the trivial modification vulnerability. It dictates exactly how an examiner must process an incoming application from a highly capitalized competitor.
Because the examiner is bound by the search results, not by common sense. When a corporate applicant submits a patent, they are acutely aware of the existing unwritten public knowledge.
Oh yeah, they take the base traditional method, bring it into their lab, and simply add one single novel limitation to that known process.
They might specify a particular synthetic solvent, right? Or a narrow temperature range, or a highly specific purification step.
And if that single, newly added limitation is not explicitly found in the printed prior art databases, the examiner's hands are legally tied. They must grant the patent for the modified process.
Let's look at concrete proof of this exact mechanism functioning in the real world. Think about the traditional Indian kumari plant, which is globally recognized, commonly known as aloe vera.
Right. Traditional Indian Ayurvedic knowledge dictates using the kumari plant mixed with standard water as a functional, highly effective cure for dry eyes.
And this oral and locally documented traditional knowledge spans centuries of continuous human application. But a well-resourced corporate applicant filed for a United States monopoly on this exact biological treatment protocol.
They didn't invent the aloe vera plant. They certainly didn't discover its biological efficacy for soothing ocular tissue, but they secured the federal monopoly anyway.
Simply because they specified the use of chlorinated water in their specific extraction process. The mere addition of standard municipal chlorine to the water was the legal trivial modification.
The examiner searched the available printed databases and found centuries of references to aloe vera and water, but they found no explicit printed publication specifically detailing the use of chlorinated water combined with aloe vera for this exact medical outcome.
So therefore, the application met the rigid statutory novelty requirement. The examiner was literally forced by the statute to clear the application.
And this exposes the ultimate lethal danger of the system, the disclosure trap. It causes a complete and catastrophic loss of leverage for the original, under-resourced inventor.
Think back to the enablement clause we talked about earlier. The original, under-resourced inventor complies perfectly with Section 112, publishing their exact proprietary blueprint to the world.
They do it in an attempt to secure a baseline patent. They follow the rules. They hand the master recipe directly to the town crier, laying bare every temperature curve and algorithmic sequence.
Because they assume the resulting monopoly will protect them from any competitors attempting to copy the core method.
But the highly capitalized competitor simply downloads and reads that perfectly drafted, publicly available application. They take your exact blueprint into their own facility.
And they specify a different solvent or a slightly modified temperature threshold, or a specific novel chlorination level. And by executing that minor technical pivot, they legally capture the market you created.
You provided the exact instruction manual necessary to replicate the technology, and they used a trivial modification to enclose it legally. You funded the R&D, and they captured the commercial utility.
Well, let's pause here and really examine the precise legal mechanics of this theoretical theft. Because I need to challenge this outcome based on the established rules of patent claim drafting.
Okay, let's hear the pushback.
The structure of independent and dependent claims should prevent this exact scenario. If a competitor patents a trivial tweak, like adding chlorinated water, the original inventor's broad base patent still exists in the system.
Sure, the base patent exists.
Right, and that base patent covers the core foundational formula of mixing aloe vera with any type of water. The competitor's patent is essentially a dependent concept.
You are technically correct regarding the text of the patent claims. The original inventor does hold the underlying broad rights. Their patent dictates the baseline boundaries of the IP.
Therefore, the corporate competitor cannot actually manufacture or sell their newly patented chlorinated version without directly infringing on the original broader patent. They would require a formal license from the original inventor.
Yes, that is exactly how it functions on paper.
On paper, the original inventor maintains absolute legal control of the market. The USPTO officially issued the original broad patent right.
He did. But you are ignoring the severe reality of how those legal rights actually exist in the physical world. Written rights do not enforce themselves. A patent is merely a piece of paper. It is not a self-executing shield.
But the federal government formally recognized the boundaries of that invention and published it in the Federal Register. The state has validated the asset.
The USPTO issues patents. It does not police infringement. The office has zero enforcement authority, zero investigative power, and zero judicial capability once the patent is granted. They stamp the paper and completely exit the battlefield.
So the burden of enforcement shifts entirely to the patent holder. The federal government provides the weapon, but you have to swing it.
Exactly. If a lean startup from Kenya or a farmer in India holds the base patent, they have to take the affirmative action. They must initiate a complex, multi-year lawsuit against the multinational corporation that's utilizing the trivial modification.
And that lawsuit must be formally filed, heavily documented, and aggressively argued in a United States federal court. This is where the theoretical legal protection violently shatters against a massive financial wall.
Because patent litigation is not a standard localized legal dispute. It is one of the most complex, resource-intensive legal battles on the planet. Taking a standard patent infringement case through a U.S. federal court costs upwards of $3 million.
$3 million. And that is just the baseline historical cost for the initial discovery phase, the Markman hearings for claim construction, retaining technical expert witnesses, and the final trial prep.
Which reveals the lethal synergy of the rules we just outlined. The different statutes do not operate in isolation. They work together in a sequence to completely corner the under-resourced player.
The system leverages your lack of capital against you. If we trace the precise mechanical sequence first, the enablement clause forces the lean innovator to publish their core proprietary secret to the world.
Right, in exchange for a theoretical monopoly. They give up their only true leverage, which was secrecy.
Second, the novelty gap allows the well-resourced competitor to tweak that newly published secret entirely legally. They introduce a minor synthetic step or a distinct solvent, bypassing the strict text of the original claims.
They create their own overlapping, federally recognized patent. And finally, the $3 million baseline cost of federal litigation prevents the under-resourced player from ever challenging that overlapping court.
The well-resourced player operates with total impunity because they know the original inventor cannot afford the entry fee to enforce their rights.
The system is not broken. It is functioning exactly as it was mathematically designed to function. It is a machine executing its primary directive.
It operates as a highly sophisticated structural extraction mechanism. It pulls unwritten proprietary knowledge into the public domain through strict mandatory disclosure requirements.
It feeds the public database with your private ingenuity. And once that knowledge is perfectly documented and publicly available, it allocates the resulting commercial monopolies strictly to those with the capital to defend them in federal court.
The written law appears neutral, but the mechanical enforcement heavily favors the highly capitalized entity. So now that you understand the precise, unyielding mechanics of the board, you must immediately alter your operational approach.
You cannot operate based on how you wish the system worked. You have to ask, how do you play your specific hand, given this harsh financial reality?
We need to outline the divergent, highly specific strategies required to survive. Your strategy must be based entirely on the actual, verifiable capitalization of your entity right now.
You must align your legal tactics with your current bank balance. So let us begin with the trap, waiting for the under-resourced founder.
If you lack the $3 million required for federal litigation, you face a severe existential structural disadvantage in this arena. The primary danger is engaging the patent system too early in your operational life cycle.
Many technical founders inherently believe filing a provisional or utility application is a mandatory first step. They think they need it for market validation or securing venture capital.
But filing that application triggers the disclosure trap immediately and irreversibly. You are legally required by Section 112 to hand an exact, replicable instruction manual of your core technology directly to your most well-funded global competitors.
And because you currently lack the capital to sue them when they inevitably tweak your design, you cannot stop them from utilizing the trivial modification loophole.
You have voluntarily given away your operational edge in exchange for a theoretical paper shield you cannot afford to lift. So, the required mandatory strategy for the under-resourced entity is evasion.
You must reject the disclosure requirement entirely until your capitalization matches your legal exposure. You do not play a game you cannot afford to finish.
This means relying heavily on strict, heavily enforced trade secrecy. You do not file the patent application. You do not publish white papers detailing your methods.
And you do not disclose the operational mechanics to the office or the public. You must aggressively and systematically lock down your back-end software architecture.
You must mathematically hide your specific temperature profiles and physically obscure your raw extraction methods from vendors and contractors. Keep the master recipe completely out of the public square.
If the well-resourced competitors cannot physically see the underlying mechanics of your product, they cannot exploit the trivial modifications to build a competing patent thicket. Secrecy is your only viable zero-cost shield.
Now look at the completely opposite side of the board. What is the structural embedded advantage for the well-resourced entity?
How do the heavily capitalized players maneuver through these same rules? If you possess the capital to withstand prolonged litigation, the system offers you the composition of matter loophole.
This is the exact legal mechanism that allowed Eli Lilly to capture the immense value of the rosy periwinkle plant. The rule is clear. You do not need to invent the biological plant, and you do not need to originate the traditional remedy.
You merely need the vast capital required to physically isolate the active chemical compound in a high-tier laboratory setting. By systematically isolating the specific compound, you create a technically new material.
Material that didn't exist in that highly concentrated, isolated state in raw nature. This precise laboratory maneuver completely bypasses the strict federal rule against patenting naturally occurring phenomena.
Once you understand this mechanism, you execute a relentless portfolio strategy. You deploy your capital to systematically process and isolate active molecules from raw biological resources, or even open-source software structures.
You define the borders of the newly isolated asset. You patent the stabilized liquid solution of that isolated molecule.
Then you aggressively patent the modern synthetic production method used to scale that molecule for commercial manufacturing. You patent the delivery mechanism and the storage protocol.
You are intentionally and methodically building a dense thicket of trivial modifications around existing, highly effective public knowledge. You surround the traditional remedy, or the open source base, with dozens of complex, overlapping patents.
And the USPTO will mechanically grant these overlapping patents because they perfectly meet the rigid text-based definitions of novelty and enablement.
The examiner, constrained by their 19-hour window and Boolean searches, will clear them one by one. The thicket grows legally.
And once that dense patent thicket is built, your sheer capitalization acts as the ultimate, impenetrable shield. The baseline threat of $3 million in federal litigation will permanently deter any original knowledge holders from challenging your portfolio.
Capital enforces the monopoly. Which brings us to the final actionable directives. You cannot unlearn the mechanics of the system, so you must act immediately based on your specific position on the board.
The theory is useless without execution. The most critical, overarching directive is to act strictly on your actual capitalization, not your desired or projected capitalization.
Do not play the aggressive disclosure-heavy strategy of a multinational corporation if you are operating as a lean pre-seed startup. If you are a lean innovator operating with limited funds, your mandatory action item for this week is clear.
Audit your entire core technology stack immediately. Do not wait for a competitor to force your hand. Identify the precise underlying mechanism that gives your product its actual operational edge in the market.
Is it a highly specific routing algorithm, an exact curing temperature for a polymer, or a unique undocumented solvent mixture? You have to locate the exact source of your value.
And then ask yourself a very simple, brutal question. Can your current balance sheet afford to spend $3 million to litigate that specific edge in federal court tomorrow?
If the honest answer is no, you must take decisive, evasive action immediately. Pull that specific mechanism out of any pending publicly accessible patent applications.
Classify it strictly as an internal trade secret today, and implement the severe, verifiable access controls required to prove that secrecy in court if an employee leaves. Build the wall internally.
But if you are a heavy hitter with significant deployable capital, your action item is entirely different. You must leverage the structural blindness of the office, access the massive public databases of traditional, oral, and open source knowledge.
Do not waste your operational time or legal budget attempting to copy the raw data or patent the base biological plants. The office's rigid rules will automatically reject those applications.
You must elevate the knowledge. Identify the most active, effective biological compounds or algorithmic structures within those traditional unpatented remedies. Send those specific high-value targets to your internal laboratory for immediate, rigorous chemical analysis.
Direct your research team to add a modern synthetic step, introduce a specific novel solvent to the extraction process, or digitize the method into a novel software architecture. change the fundamental state of the raw material to satisfy the novelty requirement.
File a robust composition of matter patent on the resulting newly isolated formula. Do not hesitate. You are simply leveraging the established rules of the board to your extreme advantage.
You are doing exactly what the statute incentivizes. The United States patent system does not measure fairness, and it does not weigh historical morality. It strictly measures mechanical compliance with the written statute.
So, play the board exactly as it is currently configured. It all comes back to the baker, the town crier, and the master recipe.
Before you hand over your life's work to the federal government in exchange for a piece of paper, you must be absolutely mathematically certain you can afford to fund the army required to protect it. Evaluate your war chest before you publish your blueprint.